So, ladies and gentlemen, dear colleagues, my name is Paweł Sobczyk. At the invitation of the organizers, I have the honor to be the moderator of the second panel on the second Polish-Hungarian Scientific Forum about international law. Let me take this opportunity to say briefly about one, but for me very important things. I would like to thank Professor Timea Hajnare-Barzo, General Director, Central European Academy, Dr. Katarzyna Zombory, Research Director, Central European Academy, and Professor Dr. János Sehnálek, Strategy Director of Central European Academy. Dear friends, thanks to you, the Polish-Hungarian Professors Network exists, and we can conduct free, this is very important, free scientific research within the framework of cooperation, and more importantly, within the framework of Polish-Hungarian friendship. I would like to thank all organizers from the Central European Academy and the partners of the conference, Faculty of Law of the University of Miskolc and Central European Association for Comparative Law. And last but not least, I would like to thank Professor Mariusz Muszyński and Professor Aleksandra Syryt for this preparation for this conference from the Polish part of Polish-Hungarian Professors Network. Dear professors, dear colleagues, I'll see on the first position in our agenda Professor Dr. Dawid Sehnálek, Vice Dean, Associate Professor from Masaryk University, Czechia, and the very long title of presentation, The Primacy of European Union Law over National Law from the Perspective of Public International Law, a legal solution for conflicts between constitutional courts and the Court of Justice. Dear Professor, dear David, the floors, the space is yours. Please start, and please remember 20 minutes maximum for your presentation.
Dear Professor, thank you very much. I hope that you can see my presentation. I apologize for a long title, and I promise that next time it's going to be short. Ladies and gentlemen, it's a pleasure to be here, and thank you very much for involving me into this project as well as into this conference. I'm really enjoying it so far. So the title has been set, so I guess I will start since the time limit is tight. Why do conflicts occur in the first place in our European area? That's a key question we are trying to address today. And the answer is that they do occur for many reasons. The European legal space is specific in that it houses several Supreme Courts which overlap in their decision-making. It is also a question of interplay of public international law, of national laws, and the EU law. And these conflicts can indeed arise very easily, not only because these courts rule on the same issues, same facts, and same legal areas, same subjects, as for example, the protection of human rights and freedoms. They may interpret fundamental rights differently with different focus on principles and values. Moreover, they often do have a different perspective on the matter and subsequently a different legal qualification. Take as an example the Polish dispute with the Court of Justice concerning the reform of Polish judiciary. The Polish Constitutional Court viewed this reform as purely internal matter for Poland, as it concerns the organization of judiciary, where European Union and the Court of Justice, they have no jurisdiction, and that is certainly true. However, the Court of Justice addressed the same situation as an interference with the rule of law. And because national courts apply and enforce the EU law, the EU has an interest in ensuring that they operate in accordance with the rule of law. According to the Court of Justice, this gives the EU the power to intervene in seemingly internal matters of member states such as judiciary. Here I'm citing the older case which concerned the salaries of Portuguese judges. And the problem with different qualification was also the problem in the case Czechoslovak pensions, which is the very first case where any of the constitutional courts of member states openly ruled against previous decision of the Court of Justice. According to the CG EU, the issue was a problem of social security regulation, whereas the Czech Constitutional Court qualified the case as purely internal, as it was, according to this court, only a matter of dissolution of Czechoslovakia, and thus something that was preceding the existence of membership in the European Union. So it is really easy for a conflict to occur, and our question is to solve them, or at least to shed some light on how to do it. I will first address the EU position, the EU perspective, but only very briefly, since the position of the Court of Justice has been shaped over more than 60 years, and it is quite clear that this court has, hasn't changed its opinion since the 60s. This court emphasizes the autonomy of EU law, both on national and on international law, which will be important for me later in my presentation. And this allows it to state that it takes precedence over national law and has direct effect in member states. And this approach has been developed in many decisions of the Court of Justice, in which with variation on national courts and a testing of the limits of primacy. So according to the Court of Justice, as we all know, the EU law has primacy over general law. That was, the case Costa versus NL, but also over constitutions, fundamental law standards. And now the Court of Justice is recently also interfering in the last island of freedom, and that's the area of national or constitutional identity. And the position is clear, the position of the Court of Justice, and it, from this perspective, its case law drive the EU policy through the EU law, and we can consider the Court of Justice as the main driver of European integration, based on the very known argument of ever closer union. When it comes to domestic courts, the national supreme courts, they have also been quite clear, at least some of them have been very clean about their position on the issue. Since 70s, they have been distancing themselves from the Court of Justice, concept primacy, and they are testing its limits. At the same time, a significant number of these courts have consistently stated that they disagree with the Courts of Justice concept and have distanced themselves from it. And it is also evident that the language they are using is increasingly strong. In doing so, they also influence the Court of Justice and its decision making in something we usually call a judicial dialogue. And so far, they have only partly been successful. On this slide, you can see my view of the depth and nature of the dialogue in those cases which touch the primacy of EU law the most. It is clear that approaches of our courts differ. I will focus, since I think that most of them are quite well known, I try to address the depth of the discussion, whether there was a dialogue, and slightly hint the outcome. And I will focus only on the last two cases, the Polish and Hungarian decisions, as they are particularly interesting from a legal perspective and from today's policy. Since both these two courts choose completely different strategies. To me, and I'm sorry to my Polish friends, but Polish Constitutional Court, to me, attempted to emulate John III Sobieski, famous heavy cavalry hussar attack on Turks in the legendary Battle of Vienna. It was very open about its opinion. However, from the perspective of judicial dialogue and EU law, I consider its decisions rather problematic, since it seems to me that the Polish Constitutional Court spoke too openly to the Court of Justice about its concept of primacy of EU law, and at the same time it also interfered in the sphere of interpretation of EU law, where according to Article 19 TEU, it's the Court of Justice who has jurisdiction. So he was perhaps too open, which is a mistake other courts try to avoid. On the other hand, the Hungarian Constitutional Court chose a much more nuanced or sophisticated approach, in my opinion, more constructive and also doctrinally very smart, since the Hungarian Constitutional Court tried to limit itself into interpreting its own constitution, thereby not directly opposing the EU law, which might be a good strategy how to influence the Court of Justice. And I also, from a doctrinal perspective, consider this approach correct because of the focus on the Constitution. And the Constitutional Court undoubtedly has the power to interpret its own law. What caught my attention when reading the translation of this decision of the Hungarian Constitutional Court, and I hope that I understood it properly, but it also was the fact that this court used a supportive argument by international law, the restrictive interpretation as a principle of international public law, which is something interesting. Let's have a closer look on this issue. So I'll try to analyze the problem from a rather theoretical perspective, not about my own political opinion on the issue. So to summarize, the perspective of EU law, the Court of Justice, is expressed in the case law of the Court of Justice, and the problem here is that it's an internal perspective of the court within the European Union. And moreover, the Court of Justice, let's face it, honestly, it's one of the parties which is involved in the problem between constitutional courts and the EU law. And nemo iudex in causa sua, after all, one should add. The position of national constitutional courts is also clear. A significant number of them have not accepted the primacy of EU law, or not accepted it as the Court of Justice has positioned it. So let's first look on the domestic law. In case of Poland, these provisions have already been mentioned in the morning. It's Article 9, and respect for international obligations. We have in our Czech constitution something very similar in our Article 1, Section 2. Then it's the provision of Article 90, which stipulates the domestic effect of acts of international law. Furthermore, the Article 8, Section 1 of the Polish constitutions, where the constitutional law is the supreme law in Poland. Again, we have something very similar, which is partly because of the fact that when amending the Czech constitution, the Czech legislator took inspiration in Poland. We copied pretty much the text of your constitution. So you should have copyrighted it, but the text is very much similar in Czech constitution. And based on that, we can draw that that we do not recognize in both countries the possibility of our legislator and executive to negotiate an international treaty that would transfer powers to an international organization beyond the constitution itself. But since the limited time, I will jump into international law, which is also from the EU perspective an external perspective. Here why I'm speaking about international law? Well, that origin of the founding treaties of the European Union cannot be denied. EU cannot fully escape the international law as such. And in fact, its law may be perceived still as its particular part. And there are authors, and quite influential, who do so, who defend this thesis that the EU law is a very specific part of international law. So this brings us to the potential solution of the conflict between domestic courts and domestic law and EU law and the Court of Justice from the perspective of someone who is third and who also has to be taken into the account. Within the international law, the Vienna Convention on the law of treaties will be important for us. Article 26 is particularly important since it enshrines pacta sunt servanda principle. Well, and this is important because it suggests that Poland is violating what it has agreed to because of Article 19 and the interpretative power of the Court of Justice, which is exclusive. This supports the position of the Court of Justice and Commission in the dispute. Then there is this Article 27 of this convention, according to which a party cannot invoke the provisions of its domestic law as a reason for not fulfilling a certain treaty, here the primary law. And this applies also to constitutional law. So argument against the Czech Republic, Hungary, Poland, and other states. And another argument is the argument by accession. We have acceded to the European Union at a time when the principle of primacy was pretty much established by the Court of Justice. We accepted the EU law as it was adopted and interpreted. So to argue now that this is not the case, therefore constitute a violation of both international and EU law. Counter-argument, we can say that this applies only to the cases of the Court of Justice adopted before our accession and cannot be extended to new, surprising cases which are ultra vires from the perspective of the founding treaties. So therefore, for example, cases related to Article 4 and Section 2 Treaty on the European Union, which concern the national identity, might be something that goes beyond this argument. It therefore seems that Poland and other rebelling states are not right from the perspective of the international law, and that it supports the European Union and Court of Justice. However, there are very good arguments in their favor as well. And these arguments are related to the rules of interpretation of international law contained in Article 21 of the Vienna Convention. Since the interpretation must be made with regard to subsequent practice established between contracting parties. And here the European Union and Court of Justice have a bit of a problem, and for several reasons. The founding treaties are silent on primacy. Everything is merely a construct of the case law of the Court of Justice. And, you know, the Article 19, which gives him this court the interpretive power, is very weak for such a decision making. Second, previous attempts to codify the principle of primacy as understood by the Court of Justice, they have failed. So there is clearly no consensus among member states, which approach is correct and which is wrong. Third, a number of member states, through their constitutional courts, have systematically and consistently rejected the primacy of EU law in its absolute sense. Fourth, the Commission has only recently begun to use the mechanism of Article 258 in the infringement proceedings. Czech Republic was quite lucky since we have not been sued. Actually, the Commission should have used this infringement in the very first Zolange case. It did not do so. So we don't have any practice here established yet. And not only did member states fail to enshrine the principle of primacy in founding treaties, they, on the contrary, tried to systematically create a space for their own law and their own values in Article 4 by enshrining the national identity, and in Article 53 of the Charter by enshrining a minimum standard of national protection of human rights. So, to sum it up, I believe that in the end, both Poland and the Court of Justice have violated the law. The former violated the EU law since it entered the zone where the Court of Justice has the right to interpret. It's tried to interpret the Article 19 and so on. The later interpreted the founding treaties against the subsequent practice among member states, since no such practice exists supporting the Court of Justice. Counter-argument might be the autonomy of EU law, which is the legal basis on which the Court of Justice bases its approach towards international and domestic law. But again, autonomy is a derivative of case law of this court and has nowhere any support. So the question is, what can we do about it? There is no final arbitrator. Either all states agree, in which case they have two alternatives, either expressly enshrining the primacy of EU law in their founding treaties, or they can subsequently amend their constitutions accordingly, or they can expressly limit the primacy of EU law and set limits to Article 19 in the area of interpretation. For example, for me, a feasible solution would be to expressly codify an interpretative principle that certain provisions have to be interpreted by the Court of Justice restrictively. Unfortunately, similar discussion was led in the case of Vienna Convention and the principle of effective interpretation, by the way. But I don't think that we will find a clear solution. Therefore, I mean, the clear support on among all member states for something like that. I myself believe in a more prudent or restrictive or more cooperative approach towards interpretation of both the constitutional law and the EU law. And here I have to say that it seems to me that whereas constitutional courts of member states were really trying to cooperate with the Court of Justice, it's the Court of Justice which is mostly failing. Thank you for your attention.